All right, let's proceed. Good morning, sir.
Mr. Chief Justice, and may it please the court, I'm John Vale. I'm here on behalf of the Johnson plaintiffs' appellants, and with me is Mr. Hoey. We'll take 12 of the allotted 15 minutes for the two cases in this session, and I'll begin by addressing the issue that's common to both of the cases, and try to persuade you why this court should not be the first court of last resort to endorse the idea that agreeing to an arbitration clause is agreeing to provide health care under a health care proxy. And I want to do that. We've briefed this. I think the first answer to this question is in the statute to which the health care proxy gives effect. And we've briefed for you the standards under that statute that very closely mirror what you want for informed consent to give medical care. It requires that it applies only to health care delivery, defined in a way that very much talks about the laying on of hands. It always talks about health care decisions, never simply about decisions. It requires consultation with health care professionals before health care decisions are made. It requires that the resulting health care decisions be consistent with good medical practice. All of those things mirror the informed consent standard that arises from, in medical care, from the concern about consenting to what otherwise would be a battery if it were not otherwise consented to. I think that standard very much captures the flavor of the text of the statute. Now, we know...
So under that analysis, would all of the forms that ask you about payment and Medicaid and Medicare and all those issues also be outside the scope of the healthcare proxy?
I don't think so, because, and this mirrors a distinction you see in the cases between optional arbitration agreements and arbitration agreements that are a condition of the receipt of health care.
So if a doctor, as a precondition to accepting any patient, asks the patient to sign an arbitration agreement concerning malpractice claims before he or she agrees to treat the patient, that doctor cannot bind somebody, a patient who is coming to him via a healthcare proxy?
I believe that is correct, Your Honor.
But he can require it of all his other patients.
That is correct, Your Honor.
Well,
you would have to have, the question is, what authority has the patient granted to the healthcare proxy? Mm-hmm. And that authority is, in this proxy, it's incorporated into the contractual agreement.
You're not suggesting it
and
can't
is
be
defined
done.
by the statute.
Right. Just would have to be like a power of attorney or something.
Exactly, and that is exactly one of the distinctions you see in the cases we've cited to you.
Is the reason that the facility here is very explicit that this was not included as a condition of admission? Is there some Attorney General regulation or something that requires that, or is there anything in the record that explains why that's so? I mean, because some of the cases...
Not that I know of, Your Honor.
Some of the cases in other states seem to make that distinction, or at least one of them does.
It seems to be. I think, it would go to, if there were such a state-based decision, I think it would be a grave risk of preemption under the Federal Arbitration Act. And I know Justice Cordy recently wrote a decision about preemption. I think that would give that some
Didn't last
voice.
very long.
I was referring to your second one.
That didn't last very long either.
But I mean, is there not something surprising by your standard, if you had a nursing home which says, if you don't sign this arbitration agreement, we will not accept you, and in your analysis, then the healthcare proxy is sufficient. But if you have a nicer nursing home which says, we ask you to sign this, but this is not a precondition of admission, then the healthcare proxy is no good.
I would not concede the first point. I say that that distinction is made in the cases. I myself don't find it a persuasive distinction, but it is not the case that's before the court here. But one reason the distinction has some persuasiveness is to go back to the question about bills, et cetera, or about, as is raised in the briefing here, about consenting to where mail is delivered and how meals are delivered. Those things are necessary incidents to providing health care in a residential setting, which is what's involved here. The resolution, the choice of forum for resolution of disputes is a very different thing. And I think the Maryland court, in its decision about that, gives probably the best extant answer on why that's so, and also analyzes I've talked only about decisions here, only about decisions of courts of last resort. The great bulk of intermediate appellate courts addressing this issue go the same way. The exception is the California courts, which go both ways, and which the Maryland court noted in its decision and said that the decisions are irreconcilable and will need to be reconciled by the California Supreme Court. But that's really the only outlier in this analysis. Now, we know, I talked about the text of the statute. We know something about what the legislature was trying to accomplish in this statute because it was a reaction to decisions about end-of-life care. And when the legislature entertained the statute that it did pass, it had also before it a proposal to do a broader sweep to amend the durable power of attorney statute. And it chose not to do that. It chose this narrow, very carefully crafted route. This statute is much more carefully crafted, much more detailed than the statute involved, for example, in the Tennessee case. It does not, not conceding that the rationale of the Tennessee case, Owens, is persuasive, but this is a very different statute with much more detail, and we know that the legislature rejected the broader formulation, the broader powers for a healthcare proxy. And to go back to your question, Justice Gantz, no, it did not authorize the healthcare proxy to do this. That could be authorized. It could be authorized under a durable power of attorney. It is possible for a principal to vest this authority in an agent. It's just that you do not do so when you sign a healthcare proxy under the Massachusetts statute. I want to give you one more reason for reading the statute in the way I suggest. And that's, there are really two components. One is, in general, you don't read grants of agency broadly, particularly when they involve the waiver of important rights. Now, arbitration does waive the right to access courts and the right to access a jury when you get to court. You have said that. The Supreme Court, otherwise mad for arbitration, has itself been very careful here, in the right case, It dealt with the question of how should you read the grant of authority to an agent to agree to arbitration. And they said, we have to be very cautious. We will read agency to include the authority to agree to arbitration only when we're specifically convinced that that is the case, that the principal chose to vest that authority in the agent. Also on this tack, and related to another piece of the statute, the statute says that any practice assented to by the healthcare proxy must be consistent with good medical practice. Now, we have one judgment of the medical community about pre-dispute binding arbitration in the healthcare setting. The ABA, the AMA, and the American Arbitration Association studied this issue, issued a report, and found that you could never have, in the healthcare setting, informed consent to a pre-dispute arbitration clause. Remember that nothing about what I'm saying now precludes these parties from arbitrating any case. These parties could agree tomorrow to arbitrate this case. They just choose not to. Arbitration is a matter of contract. Choice and consent are the elements of it. They are not present here. Your Honor, my time is about to run off.
If I could
I'll
keep ask one question about practicalities. Assume you're right. Assume you have an Alzheimer's patient and there's no durable power of attorney. What's the process to get a durable power of attorney from an elderly person who through dementia or Alzheimer's is incapable of giving consent to it?
I believe in general that you have to impose a conservatorship.
So you have to go to a court.
You have to go to a court.
Or
So the
guardianship.
practical consequence of your result would be that you would have to go to a court to get the power to sign certain forms.
An arbitration agreement, or what would you have to do if the person were going to sue? I mean, you can sue through a conservator or perhaps by a next friend, differs from jurisdiction to jurisdiction. But again, you always have a court supervision of the decision.
Thank you, sir. Let's proceed.
May it please the court, Your Honors, Christopher Lavoie for Kindred Healthcare, the defendant appellee in this case. This case has been consolidated for this oral argument with another case, Licata versus Malden-Dexter. Counsel for Malden-Dexter will be arguing the issue that you've been dealing with here as to whether a healthcare proxy can sign a pre-dispute arbitration agreement in the nursing home context. So as not to be redundant, we split up the argument, and I'm going to be addressing the issue of whether the beneficiaries under the wrongful death statute can be bound to an ADR agreement signed by a nursing home resident. The easiest way to look at this analysis, and we are jumping ahead, and I do agree that if you find that a healthcare proxy cannot sign an ADR agreement, you do not get to this argument in this case. However, a good way to look at the analysis starting at this point is having a valid binding ADR agreement. So this is not the facts of this case, but if you have a nursing home resident who comes into a nursing home, is cognizant, competent, and lucid, signs the admissions paperwork on his own behalf, and as a voluntary part of that also signs an alternative dispute resolution agreement, is that agreement then binding on his statutory beneficiaries under the wrongful death statute should that person pass away in the nursing home? First of all, what do we know in that situation? We know that it is the intention of the signatory to that ADR agreement to bind his successors to that agreement. How do we know that? If we look in the appendix at the ADR agreement at issue in this case, it specifically says that it shall be binding on successors and actually goes on to list the people who could potentially be collectors under the wrongful.
But doesn't the wrongful death statute, cases under it, suggest that the action belongs not to him or his successors, his estate, but to the statutory beneficiaries? There might be overlap, but not necessarily.
Your Honor, I think that what we need to look at there is who holds the cause of action in a wrongful death case. And the statute is very, very clear on
Brought by the estate, but it's on behalf of the statutory beneficiaries.
And in fact, think of it this way, Your Honor. If you have two statutory beneficiaries, two daughters of this nursing home resident, who would be the beneficiaries under the statute, one wants to bring a lawsuit about their father's passing away at the facility, one doesn't. They're both adamant about their positions. One of them is going to be very disappointed because the only person that can bring that wrongful death case is the executor or administrator of that estate.
Yeah, but isn't the better inquiry to look to see whether the claim is derivative or independent?
Absolutely, and Your Honor, it is, I would say, ridiculous to say under the Massachusetts statute that the wrongful death action, cause of action, is not derivative of what happened to the decedent. And here's why. Think of it this way. In Massachusetts, under our wrongful death statute, you can have a wrongful death case with no statutory beneficiaries, someone that doesn't have any relatives or anyone to or next of kin that would collect under the statute. However, you can't have a wrongful death case in Massachusetts without a decedent. Someone needs to die, and the entire wrongful death case is derivative of that underlying tort and what happened to that person and that action. Now,
But have we ever said that it's that kind of an action is a derivative claim? The way we've said, the way we've described loss of consortium as derivative.
I don't believe in the wrongful death context that there's a lot of language, as Justice Lenk said, talking about it being the action being held in trust for the statutory beneficiaries, but I don't believe there is specific language like that. Another.
So we could say, in answer to Justice Lenk's question, that it is an independent claim. I mean, this would go against you.
It would, and you shouldn't say that because the legislature, had the legislature intended that, they would have put that in the statute. The legislature could have crafted the wrongful death statute in Massachusetts to be brought by the statutory beneficiaries. Anybody who's a statutory beneficiary under this statute can join in and be the plaintiff in the case.
Yeah, but the reason they come together is for the sake of convenience. We want both of these actions to be brought at the same time and have them heard in the interest of, together in the interest of judicial economy.
Exactly, Your Honor. And that's another reason why the statutory beneficiaries should be bound under an ADR agreement like this, because the wrongful death statute has damages that flow to these statutory beneficiaries. It also has damages that flow to the estate. Section 6, conscious pain and suffering, flows to the estate. So if you have a nursing home resident signing one of these ADR agreements and he passes away, the conscious pain and suffering portion of any potential dispute would be bound under the ADR agreement. That would have to go to ADR. And I don't think the court should do this, but should the court then rule that the statutory beneficiaries were not bound by the agreement, that could potentially go to court. And there would be a second avenue through which that would be decided. As a practical matter, these ADR processes are always much more efficient than going to the court system. And in fact, in this particular case, the ADR agreement calls for a mediation and a binding arbitration to occur within 6 months. So you would have a binding arbitration having already occurred as to that underlying tort and the cause of that person's death for the conscious pain and suffering portion, which potentially would have precedential value about the part of the case that is progressing through the courts.
It would be very interesting because it would be the same people would be bringing it.
It would be the same people, and as a practical matter, an absolute mess. One final issue I'd like to raise, Your Honors, is that a ruling that the statutory beneficiaries under the wrongful death statute are not bound would basically do away with pre-dispute arbitration agreements in the nursing home context. And the reason for that is that the bulk of the residents in nursing homes are elderly, and the bulk of the cases that are brought are wrongful death cases. Therefore, if you rule that the statutory beneficiaries are not bound by those agreements, it basically does away with arbitration in the nursing home context. And it is well agreed that arbitration is favored by this court and many other courts as a way to resolve disputes. I see that my time is almost up, Your Honor. If there are no questions.
Thank you.
Thank you.